3.25 years ago, Sri Lanka emerged from a long drawn-out conflict to eliminate terrorism, successfully conducting a humanitarian operation to free a captive population with a view to bringing about lasting stability, peace and prosperity that had eluded our nation's people for nearly 3 decades. In the aftermath of this operation, it was established beyond doubt that the Sri Lankan government was doing its utmost to continue promoting and protecting human rights of all its citizens. The reconstruction, resettlement, rehabilitation, reintegration and reconciliation program demonstrates that Sri Lanka today is well on the path to usher in an era of sustainable development, social progress and durable peace. Reconstruction includes restoration of physical and social infrastructure, strengthening of civil administration, provision of livelihood support and housing. As a result, a 27% growth rate has been recorded in the northern province, the former theatre of conflict, while Sri Lanka's overall gross domestic product recorded around 8% growth in 2011. Unparalleled progress has been made in areas such as the resettlement of internally displaced persons, facilitated by demining. The last batch of IDPs were resettled in their villages in Mullaitivu on 24th of September 2012. The resettlement of the final batch of IDPs marks a day of historic significance, as the resettlement is now complete and there are no more IDPs or IDP camps in the island. This makes the achievement reached within a short period of 3 years remarkable when compared with similar situations in other parts of the world. Mr. President, to address issues pertaining to land, the government is in the process of establishing a land commission. The terms of reference of the 4th Land Commission are now being formulated as we speak. This is in accordance with the LLRC recommendations on land return and resettlement. With the termination of military operations and the gradual restoration of normality, the strength of the military in the north has been reduced considerably. Further rationalization of this presence would be considered in line with national security interests. Mr. President, the government is in the process of devising measures to pay compensation to the owners of properties within such areas or provide them with alternate land. I must re-emphasize that the military is in no way engaged in civil administration, which is the sole responsibility of civilian officials. A significant aspect of the resettlement process is demining. The Sri Lankan Army was responsible for demining approximately 75% of the land, which was the largest single area assigned to any of the parties involved in demining and included most of densely mined regions. As of January 2013, about 99% of the areas identified for demining have been cleared and less than 98 square kilometers of territory remains to be cleared. With regard to the rehabilitation and subsequent reintegration of ex-combatants, from approximately 12,000 persons at the inception, as of 15 January 2013, 396 beneficiaries, 378 male and 18 female, are undergoing rehabilitation and 225 are under legal proceedings under judicially mandated custody, remanded or bail. As of 15 January 2013, 11,456, roughly 9,200 male and 2,250 female persons, including 594 former LTT child combatants, soldiers, have been rehabilitated and reintegrated into the society. It must be noted that Sri Lanka has now been delisted by the UN Secretary General from Annex 2 of the UN Security Council Resolution 1612 on children and armed conflict. The working group has adopted the draft conclusions on the situation of children and armed conflict in Sri Lanka on December 19, 2012. thereby closing the dossier on Sri Lanka in the Security Council. A court of inquiry was established by the commander of the Sri Lankan Army to inquire into the observations made by the Lessons Learned and Reconciliation Commission, we call it the LLRC, in its report as to alleged civilian casualties during the final phase of the humanitarian operation and the controversial Channel 4 video footage, irrespective of its authenticity or otherwise. The Court of Inquiry will now proceed to investigate the second part of their mandate, which is to examine the Channel 4 allegations. We will of course keep the Council informed of its developments. In relation to the killing of 5 students in Trincomalee and the 17 ACF workers, this was during the conflict period, the police are conducting further investigations guided by a special team of senior prosecutors specially mandated for the purpose of examining documents and other forensic material that may be useful to conclude the investigations relating to these 2 cases. The government of Sri Lanka's efforts continue through the relevant agencies to bring finality to the crimes involved in these 2 cases. I am able to announce, Mr. President, that in the case of the 5 students, the Attorney General has instructed the police to commence a non-summary inquiry before judicial authorities. This is a significant development. Thus, this matter may be brought to a conclusion and is concrete evidence of our commitment to accountability. The LLRC recommendations are being implemented by the corresponding implementing agencies under short, medium and long-term goals based on priority considerations within specified time frames. As to the proposed Parliamentary Select Committee, the government is of the view that it is the most appropriate forum on this matter since constitutional reforms need a 2/3 majority and a broad national consensus. While the government has nominated its representatives to the Parliamentary Select Committee, the nominations of the opposition parties are awaited. Provincial elections are envisaged to be held within the course of this year for the Northern Province in keeping with the Provincial Council's Elections Act and relevant judicial pronouncements interpreting the provisions of the law. Despite these gains within Sri Lanka, remnants of the terrorist organization remain very active in some countries in the Western Hemisphere, where their proxies are continuing to lobby host governments, opinion makers in the media and elsewhere to undermine the peace and reconciliation process that is ongoing. It is regrettable that some part of the international community has fallen prey to these efforts based on disinformation, outright falsehood and pressure tactics. This has at times resulted in biased and unequal treatment for Sri Lanka. An example of this selective and inequitable process seeking punitive action on Sri Lanka are some efforts in this very council. We believe that resolution number 19/2 on Sri Lanka, which was introduced and adopted at the 19th session of the council on the 22nd of March 2012, was entirely unnecessary, unwarranted and unfair. Moreover, as is already announced in this council and elsewhere, a follow-up draft resolution on Sri Lanka, already circulated I believe, is to be introduced at this session a year after the earlier resolution. We strongly object to any unfair, biased, unprincipled and unjust approach that may be adopted by this council with regard to the protection and promotion of human rights in Sri Lanka. We are therefore firmly of the view that this council should not embark upon or encourage either debate on or any country-specific resolution by virtue of a selective process which would run counter to the founding principles of this council. Doing so will clearly reflect an application of double standards. Mr. President, it is our position that it is the government's primary responsibility to resolve domestic issues. Unwarranted internationalization of such issues would only undermine the local reconciliation process in Sri Lanka, a process that is still ongoing impacting adversely on the people in the former conflict-affected areas in their efforts to reap the dividends of peace. Targeting Sri Lanka unfairly in this manner would only serve to further polarize the affected parties, particularly considering that there is no imminent threat to the human security of its citizens or to international peace and security. The bona fides and the objectivity of the proponents of action on Sri Lanka may therefore be questioned. Moreover, the subjective selectivity in focusing on Sri Lanka in this manner, a country which has always cooperated and engaged with the United Nations system and the international community, is unacceptable. Sri Lanka is of the view that country-specific action in the Human Rights Council, such as Resolution 19/2, is a selective and arbitrary process which is not governed by objective norms or criteria of any kind. It is our firm belief that it is vitally important for the structures and procedures of multilateral organizations to be uniform and consistent and devoid of any discrimination. Mr. President, in this context, the report of the High Commissioner for Human Rights, titled Advice and Technical Assistance to the Government of Sri Lanka on Promoting Reconciliation and Accountability in Sri Lanka, has been compiled pursuant to Resolution 19/2. This report will be considered later during the session. Comments and observations of the Government of Sri Lanka in general on the High Commissioner's report were forwarded, and our comments in full are placed on the website. In relation to further engagement, it may be recalled that an invitation was extended to the UN High Commissioner for Human Rights in April 2011, almost 2 years, for a country visit. Thereafter, according to a report, she indicated in May 2012 that the visit to Sri Lanka will be undertaken after an advance visit by a team of officials from an office to explore possible areas for cooperation, and I quote, to help prepare the ground for an eventual country visit by the High Commissioner herself, unquote. The High Commissioner expressed her satisfaction with the cooperation extended by the Government of Sri Lanka to her delegation, whose visit in September 2012 was facilitated in close consultation with the UN country office. I myself met the team when they were in Sri Lanka.